Good morning, everybody. Welcome to today's webinar, looking at ethical risks and safeguarding in digital projects. And the webinar is brought to you by The Space. I'm Linda Coburn. I'm the moderator for the webinar series. So this morning, what I'll be doing is just talking you through the plan for the webinar, how we'll work, and then we'll crack on with the content, looking at the issues for the day. Okay, so just to set out how we work, really, there's three things which you may already know, but which is one is that we use the chat a lot. And as you come in and join, you may well want to say hello in chat, tell everybody who's here, and use it to ask questions of our panelists and also to discuss points and issues between yourselves. And we have a live captioner with us today, Jen, and she's put the links into chat explaining about how you can find live captioning if that's helpful to you. So the information is there and the link is at the bottom of the Zoom screen. And the third thing to bear in mind is that we record the webinars and the recordings are then made available on our YouTube channel for a period after the event so that you can go back to it and see it. You might want it for accessibility or you might want to share it with your colleagues. So that's really about how we work, and we really encourage sort of chat and conversation in chat as we go along. And then next, just to give you an overview of how this morning is going to run. So we're running till 12:30. First of all, you'll hear from Fiona Morris, the CEO and Creative Director of the Space, setting out why we're doing this, why we think this is an important issue for now. Then you're going to hear from Catherine Allen, who is the CEO of Limina. And Catherine has put the panel together and is really thinking about these issues in some detail. And then we'll be so she'll do an overview, and then we'll get into more specific aspects of looking at the Online Safety Act with Andrew Bravin, a lawyer at Sheridan's law firm, and Rich Collard, who works with the NSPCC. So they'll be really digging into some of the issues. And along the way, we've got plenty of time for questions directed to the panel. So if at any point you have a question, add it into chat or just wait until the point in between. And we'll have a break in the middle. We'll have a break in the middle for a comfort break of 5 minutes. Okay, somebody has a hand up, but in this Zoom, the thing is that you'll have to type the questions into chat. We don't have a way of making your cameras and microphones live. So if you just want to do that, that would be great. Okay, so that's how we're going to work, what's going to happen, and I'll be collating all the questions and asking them of the panel as we go along. So to kick us off, I'm going to invite Fiona to join us, Fiona Morris, just to give an overview and start the session. Thanks, Fiona.
Morning. Good morning to everyone. Thank you all for taking the time to join us today. I'm the CEO and Creative Director of The Space. For any of you who don't know who we are, just a really brief piece of background here. We're a digital commissioning and development agency. We work with artists and cultural organisations all around the UK. We were first set up in 2014, but as of 2023, we have now joined the Arts Council of England's national portfolio. We support organisations to explore the potential for using new digital technologies within creative practice and to develop their use of digital platforms from traditional broadcast to social media to really help extend the reach of work and the breadth of the audiences that are connecting with that content. So that's kind of the brief background to us. Why this webinar? That's really kind of the broader piece around our learning and resources programme. Alongside the commissioning programme, which is very central to what we do, we're also interested in exploring and sharing with the sector the wider context of this kind of massively rapid and iterative adaptation and adoption of digital technologies, the opportunities, obviously, but they're extensive, but also the challenges that then we face from them. And right now, there are obviously lots and lots of debates taking place within our communities, within our societies, concerning the kind of moral and ethical challenges and complexities attached to many of our new breakthrough technologies, from cultural war debates around social media to the potential for, obviously huge potential for benefit from AI technologies, but also the potential for their misuse. And within the UK, central to that discussion over the last few years has been the original consultation, the debates, and the recent adoption of the government's online safety bill. And the breadth and range of powers and sanctions contained within that act have the potential to impact many areas, including arts and culture, but way beyond that. And we wanted to have an opportunity to explore that a bit further. We think this is probably the first time it's actually been discussed purely in the context of arts and culture and the implications for our sector. And given that I think we've had about 140 people signing up to today, it's clearly something that many of you are also keen to get more information about. Our contributors today have all had close involvement in discussions outside of the Act, but also within it as well. And we're delighted that they're all able to join us today. And I'd like to start by welcoming the host of our conversation today, which is Catherine Allen. Morning, Catherine.
Hi, good morning.
Catherine is the CEO and lead consultant at Limina Immersive. She's one of the UK's leading experts in immersive technology and its responsible use. A BAFTA-winning creative technology specialist, she founded the AV and VR consulting and research company Limina Immersive in 2016, and she's worked with the space on and off since then. And we've been delighted to have her kind of expert opinion on a range of subjects. Limina now advises on the responsible use of many of these emerging and immersive technologies, and in particular, I think it's sort of fair to say, designing the sort of safe spaces for that to take place in. Her work has played a significant role in informing government, corporate and third sector policies, and she's been featured as an expert on BBC Radio, in the press, in The Guardian, Wired and the Sunday Times. So with that big build-up, Catherine, I'm going to hand over to you and thank you for hosting today.
Oh, thank you for the lovely introduction. I'm just going to get my slides ready. 1 second. There's a new fancy feature on Zoom where you can you see me with the slides in the background? Hopefully that works okay. So yeah, thanks so much, Fiona, for the introduction. And also thank you everybody for joining us here, for being part of this webinar about such an important topic, which I think will likely emerge as increasingly prominent in 2024. Obviously, as the Online Safety Act is now an act, it's gone through Parliament, it's gains momentum, it will come into force. As that happens, but also generally, I'm sure that many of you will seen a really good thing is that there does seem to be a sort of cultural shift, a cultural change, is that organisations, tech companies are more aware of the conversation and the need to consider ethics and safeguarding for digital projects. So yeah, this new law, thinking about the Online Safety Act, it will affect every sector. And of course, if it affects every sector, this includes arts and heritage, where there's mainly when there's a digital component involved. So whilst your digital projects might not be in scope, not everything's going to be in scope, there's a lot of industry analysts, and I guess I'd include myself here, who predicted general cultural change, sort of akin to how GDPR gave a public awareness around personal data. So I think now is a really good time, because there's going to be likely a general cultural shift in sort of what audiences want, what they're aware of, and of course what we all want to do. It's a good time to think in general about ethical risk and about safeguarding in digital projects. But of course, you guys being cultural sector, I'm sure you already have a keen interest in safeguarding and managing ethics and ensuring, the best, most ethical projects possible, and that's why you're here. The UK culture sector has such a strong background in promoting responsible practice. I mean, for instance, if you look over the last over a decade of dedicated work to improve diversity in audiences in the sector, there's a really good heritage here already. So we're building on a lot. So today what I'm going to do is I'm going to share a way of thinking about digital innovation in the cultural sector, where I'm really going to focus in on risk assessments here, because that's part of the Online Safety Act, quite key. Where they're baked in, risk assessments are baked in from the very beginning. They're part of the Online Safety Act, as I mentioned, but they're also a form of just general good practice, as I'm sure you know. So I've been sharing this approach sort of long before the Online Safety Act, sort of as a consultant, also as a practitioner. And of course, the format of a risk assessment is probably something familiar with already, but this is a sort of way of applying it, a way of thinking, which sort of considers that broader societal risk and potential harms. And then after my presentation, I'm so lucky to be joined by two really fantastic and knowledgeable experts, and with both with a focus on the Online Safety Act. So Rich Collard from the NSPCC and Andrew Bravin from Sheridan's, the law firm. So I'll just tell you a bit about them now. Obviously, I'll introduce themselves a bit more when they speak. So I'll start off by presenting, and then we'll have some Q&As in between, and then we'll have the over to.
I'm just checking out loud whether anybody else can hear Catherine.
No, Linda, I
Right.
can't.
Okay, I've lost her too. So I wonder whether we might ask, I don't know how Andrew is fixed, whether we should see if Andrew can hear us and whether we could go the other way round. Are you there? Oh, you need to unmute.
Hi.
So this would be a bit unexpected, but let's see if we can give Catherine a bit of time. So what was going to happen, can I just give her a bit of preamble so this makes sense? So Catherine was really going to do the overview, talking about risk assessments as she's saying, and then get Andrew and Rich to talk in more detail about the Online Safety Act. But I think in the context of this, if you wouldn't mind just giving us your overview of the Online Safety Act, and then we can go back to Catherine when we can get her back. Is that okay?
Yeah, sure. But yeah, so this has been a long-awaited legislation. Kind of started in 2019 with a government white paper, and the white paper talks about sort of all singing, all dancing duties of cares for online sort of service providers, and the issues they're looking to tackle are both illegal issues, so breach of existing laws, but also tackling the problem of harmful content. And so harmful content is content that isn't necessarily illegal, but it is still harmful. And Richard will talk, I'm sure, later about how why some content is considered harmful and the damage it does, in particular to certain categories of society like children, and why there needs to be duty of care on these internet service providers. So the white paper was published in 2019. There was then a period of consultation, and the government published its response in 2020. There was then the draft bill, which came in 2021, and the act was actually passed at the end of October 2023. And it was quite, to be fair, watered down from what was originally discussed in the original white paper that was published in 2019. But yeah, I mean, on a very high level, what it's looking to do is put a duty of care on internet service providers that are within scope to tackle both illegal issues on their platforms and harmful content that's on their platforms. And I mean, we'll get into it later, sort of what is what is in and out of scope. But if you are in or without scope, then there's certain things you're going to have to think about. And essentially, again, on a high level, it's thinking about transparency. How do you deal with these issues? Undertaking risk assessments to consider the particular problems that your platform might have. Transparency about how you're tackling the issues, and so on. And I think, sort of Catherine's introduction there was sort of touching on the wider movement here, which is really happening on a global scale, because we also had, in addition to the Online Safety Act, we've had the Digital Services Act in the European Union, which is a similar, does a similar thing, or many similar things to the Online Safety Act, and it's again, imposing duties of cares on service providers.
Yeah.
Now, historically, there hasn't been anything like this, so this is quite a big change, because the sort of main bit of legislation for tackling issues on online platforms historically was the e-commerce directive, and that was a European legislation which came in 2000. And the key thing there was the main take home from the e-commerce directive was that if you had illegal content on your platform, then you had to remove it. There was a requirement to remove it expeditiously. And so some of you may be familiar with sort of takedown notices, which there was a big focus obviously on intellectual property, tackling intellectual property issues on platforms. So that's historically all we've had, and that was a problem certainly in my practice with dealing with games companies who are accessed by children. There was a clear legal process for a requirement on providers to remove IP infringements or illegal content, but when it came to things like bullying, alleged harassment, promoting content that's not suitable for children, there wasn't really a legislative mechanism for doing that. And all those problems have been kind of very much in the press, all the problems certainly with all the very popular social platforms that we have these days and the associated issues. And so really what this legislation and what the Digital Services Act is trying to do is trying to plug that gap between illegal issues and harmful issues, and to impose a duty of care on service providers in the space.
I just want, sorry to interrupt you, but just we know from Catherine that she's having quite a few issues. So I'm going to ask you if you wouldn't mind just kind of going onto your presentation. Are you ready to do that? So I think, and while you're doing that, thank you so much for this the change, and thank you for bearing with us. So I think, when you hear those words as a person who's not a legal expert, they're, bullying, harassment, legal, they're all quite sort of scary words. And I think what we haven't really got into at the moment is, I think Catherine hinted at it, for a lot of the organisations here, they won't be directly affected by, this is, please don't feel like, oh my goodness, we're going to have to all going to have to rush up and do lots of things. Go on, Andrew, you're going to say something.
No, I think, I think so. Yeah, certainly the focus today for me is to give you an overview, and there's two things that my presentation is focused on, which is whether you're in and out of scope. And as Linda mentions, I imagine a lot of people here might be out of scope, but that doesn't mean it's not relevant for content you're creating and partners that you have, that platforms that might be exploiting content you've created. So it's still useful to have this in mind. And then also I'm going to sort of focus on the core things and requirements that you'll have to do. So shall I jump into my slides perhaps?
That would be great. Thank you. Thank you very much.
Let me just see. Can everyone see that?
Yes.
Yeah.
Yeah.
Okay. I'll just do. Okay. So as I said, kind of covered this, but it's been a long time coming. 2019 was the original white paper, and it's looking to create a safer internet services for individuals in the UK. There's similar laws in the EU and in places like Australia, and I think, as Catherine was suggesting, there's going to be more of a movement globally across this. So whilst it might not be that you're operating a platform that's in scope, you still may need to have an awareness of it, just to ensure that platforms where you're exploiting content are doing so in accordance with their obligations to avoid sort of reputational issues. So just to give some context and some understanding of what we talk about when we're talking about harmful content and when we're talking about illegal content and legal harms. So harmful content, as we've already touched on, are things which there isn't actually legislation that tackles, but this legislation is now trying to introduce duties of care on service providers to tackle. So it's things like online abuse, cyberbullying, online harassment, content which was promoting suicide, self-harm or eating disorders, or that encourages drug use and violence. And then the Ofcom guidance to the Online Safety Act lists 15 types of illegal harms you may want to consider, and it ranges from terrorism offences, child sexual exploitation, hate offences, harassment, unlawful immigration. So there's a whole load of illegal harms, which hopefully the audience today shouldn't encounter too much, but these are also the types of harms that service providers are going to have to protect users from. So as I mentioned, Ofcom is going to be the regulator and has been appointed under the Act as the regulator for the Act. So similar to the ICO for the Data Protection Act, they will be publishing guidance, and importantly, the obligations on people that are service providers that are within scope will all be set out by Ofcom, and so they've published some of this already, but some of it is still to come into play. The Ofcom website is a fantastic resource if you want to get to grips with the basics on this. There's loads of guidance on there, but the guidance is still sort of being drip fed, and it won't fully have come into force until the end of 2024. So there is quite a while still to get to grips and understand what your obligations may be under legislation. And that's the timeline from the Ofcom website. So who's in scope? And this is the question that we're being asked mainly at the moment. Will I be in scope? Will this matter to me? And so there's sort of broadly three types of service provider which will be in scope. There's providers of internet services that allow users to interact with content generated, uploaded or shared by other users. There's providers of search engines that enable users to search multiple websites and databases. And there's providers of internet services which publish or display pornographic content. So that's pornographic content that's published by a provider. So when you're deciding if the rules apply to you, there are three things that will need to be considered. Does the service have links with the UK? So is it capable of being used by individuals in the UK, and is there a risk that they may be exposed to harmful content? In some ways, that's similar to consumer laws in that, you know, if you're selling products into the UK, you'll have to comply with consumer laws. So it's similar here. If content is being exploited or to a UK audience, then this is something you have to consider. Do you provide a relevant service? And that's those three services that we've looked at. And then you need to consider whether exemptions apply to your service. And there are some exemptions which we'll look at. So starting with user to user. So user to user service is an online service that allows users to interact with each other. And that's the important bit, that you can interact with each other. Interaction could be with images, videos, messages or comments, or with other users that using that service. So it's always helpful to have some examples, but examples of user to user service would be obviously social media websites or apps, photo or video sharing services, chat or instant messaging services where users can talk to each other, games with interactive user to user capabilities. Could also include marketplaces where users can interact. So, you know, eBay talking to each other about sales of products. Also forums. So if it's a forum where users can talk to each other and display messages directed at each other, then that will be within scope. Moving on to search service. So search service is fairly self-explanatory, but it's an online service that will include a search engine. But the key point here is that search engine allows a user to search more than one website or database. So if it's just an online search capability on your own website, then that wouldn't bring you into scope and you wouldn't count as a search service. Also, if you're a service that's just embedding a third-party search engine onto your website using plugins, then it's likely, and we'll need to follow the guidance, the Ofcom guidance on this one, but it's likely that the rules will apply to the third party, not you embedding the product, the search engine. Pornographic content. So the Act defines pornographic content as content that was produced solely or principally for the purpose of sexual arousal. It only includes audio, image, and video content. So it doesn't include text or written content. And there are specific parts of the Act that will apply if you are publishing pornographic content. The kind of key elements of those are obviously that you'll have to have age verification and assurances, and the guidance talks about that being kind of a higher threshold than just having a tick box. You know, you have to have an age assurance system so that you can confidently ascertain that users will be of the required age. So there are some limits to the ways that, some exemptions to some of those services. And for the user to user, so remember the user to user is where you've got capabilities for users to the provider to talk to each other or interact with each other. If the only way that users can communicate on your services by email or text or by one-on-one live oral communications, then that's an exemption. Also, and this is quite an important one, I think, is if users can only interact with the content that you, the provider of the service, publish, then it falls within an exemption. So, for example, if you had a comments capability on your website or on your service, but people could only comment, they couldn't interact with each other's comments, then you'd be exempt and outside the scope of the services, the legislation. Also, very sensibly, there's exemptions for internal business user-to-user services, so business intranets, content management systems, customer relationship management systems. Also, perhaps relevant to some of the audience today, if it's a service provided by a public body, a UK public authority, or a UK education or childcare provider, then you will be exempt. So the next, aside from the whether we'll be in scope, out scope, the next most asked question we have is, well, what's the type of things we're going to have to do? And one of the first things you have to do is take a risk assessment, and the risk assessment, there is guidance on the risk assessment on the Ofcom website already, and that will allow businesses who think they may be in scope to understand what types of risks there are and issues there are that they'll have to put in place steps to tackle. And then these are the steps that are recommended on the Ofcom website for all service providers. There are additional steps for pornographic content, for child linked services, but these are the kind of main steps that you have to be taking. So you have to have a named person accountable for compliance with illegal content safety duties and for reporting and complaints duties. So similar to a data protection officer, if you think you're within scope, you're going to have someone that's the person appointed to tackle and to manage these issues.
Can I interrupt you? Sorry, just ask a question about, because there's loads, I'm just looking at loads of information here. Are we able to share your slides after the event with the audience? Yeah,
absolutely. And I would say a lot of this content is taken directly from the sort of the Ofcom website, which is, you know, if it is really helpful, and that's going to be the go-to destination for the guidance. And as I said, the guidance is still in draft format, a lot of it, so it may be subject to change. But if you want to get to grips with and get ahead of what you're going to need to do, then I strongly recommend you go to the Ofcom website, look at the online safety section, and there's lots of things that you can be doing already.
So we don't need to remember everything that.
No, you don't need to remember everything. This will be widely available.
Thank you.
You're welcome. And so you'll also have to have content moderation systems or processes designed to take down illegal content. I think the intention there is that there will be different thresholds. So the massive social platforms, or where there's huge users and there's higher risks of harmful and illegal content, we'll have to have more sophisticated content moderation systems. Whereas if you're a smaller organization, having an email and a clear system for tackling that will be more appropriate.
So just to jump in there, so we've got a question which is relevant to this, which is saying, does this apply to, somebody's asking, do the comments interactions rule, and I guess more broadly, all the rules, apply to business/organisation social media channels, or is that down to the service provider, like Facebook or Instagram, the platforms?
It'll be the platform. It'll be the service provider. It won't be, it'll be. So I guess the question is, if you had a business page within a social platform, would you be responsible for compliance with the Online Safety Act? Well, no, it would be the actual provider of the service itself. So that would be Facebook, or that would be Instagram, or Meta. So it's the provider themselves. It wouldn't be you individually.
Thank you. And just to let you know that Catherine's back and live, so you don't have to take on the whole webinar, Andrew, is what
No, great. So I'm just going to whiz through. So obviously you have to sort of have content moderating systems. You have to have complaints processes available. The complaints processes need to be easy to find, easy to access, easy to use. You need indicative timeframes for considering complaints. Illegal complaints are going to have to be handled in accordance with any recommendations from Ofcom, which will be published from time to time. Terms of service is a key one. You're going to have to, if you're within scope, you need to update your terms of service to make sure it's clear on how individuals are protected from illegal content, harmful content, and how complaints are handled and resolved. Terms of services will need to be clear and accessible. And there are higher threshold requirements if, for example, there's suspicions that accounts are being used by terrorist group. Those will need to be removed. Sorry. So the practical steps organisations take immediately or now are to carry out risk assessment. And there's, as I've said previously, there's guidance on how to do that on the Ofcom website. Take a review of your current complaints procedures. How do you currently deal with harmful content? Is there anything you need to consider now in light of the Act that changes the way you deal with harmful content? Do you have the appropriate mechanisms for dealing with complaints already, or do you need to make changes? And do you need to review your terms of service, because your terms of service will need to talk about how you're tackling all these issues. You also need to consider how to balance freedom of expression, which particularly for arts-based businesses will be something they need to consider. With that, the new duty of care to protect users from harm. Keep close tabs on Ofcom's guidance. As I said, that's key, and that's going to be coming out across the year. Also, where you're working with platforms or where you're commissioned to create content for third parties, you probably need to, like with data protection, start thinking about, well, do I need to ensure under my contracts, or do I need to do a little bit of analysis on whether the platforms are compliant with data privacy, but also are they compliant with the online safety laws? Is there things I need to think about? Because whilst you may be the one creating the content but not actually exploiting it on a platform that's in scope, if there could be reputational risk if that platform is found to be breaching lots of online safety rules. And also consider whether content will be appropriate for the platforms that it's going to be featured on. And so finally, as again, sort of Catherine was introducing, there is kind of a broad landscape now of things and laws and to consider when creating content and exploiting content and using content on platforms. So there's already data privacy laws, which I'm sure a lot of you are familiar about, but you always need to be having those in mind. You need to be thinking about IP protection, whether you're exploiting other people's IP, and consider those. There's also consumer laws that are relevant for digital and online platforms. But now, additionally, we have online harms. So it's an additional thing to consider. And I think the regulation of online spaces is only going to keep getting more and more, particularly with new technologies like AI. That throws something different into the mix. And so I think for sort of diligent people working in this space, it's always good to have an overview or an understanding of that landscape. And yeah, there is a tension. Critics of online harms argue that this may cause censorship issues. There's been sort of issues on Instagram with the sort of free the nipple issues. And so there's always that tension, I think, for arts organisations as well. But yeah, that was my hopefully giving you an overview of the Act and the key things to think. But happy to answer questions and to.
Thank you.
As you need.
That's great. Thanks, Andrew. I think what we'll do is go back to Catherine to kind of get that overview. That you have raised some really interesting points around sort of freedom of expression, the question of AI. So we'll come back to those at the end of the session. So we'll get back to Catherine to kind of go back to the basics. But I wondered, Andrew, there was a particular question in there. If you look in the chat about charities, and I wonder if you have an answer to it, would you mind just writing it into chat and we'll get Catherine to carry on?
Yeah, sure. I'll have a look and then.
All right.
Yeah.
Thank you. Thanks ever so much.
Thanks.
Turn your screen off and everything now.
Yeah.
Lovely. Thanks so much. That was brilliant. Okay, Catherine, are you there?
I'll share my screen. Bear with me 1 second, and it's back to where we were.
So while you're doing that, can I just say out loud, if you disappear again, I'll come to Rich and we'll go into more of the detail and then hopefully come back to you.
Great. I even tried on my partner's computer as well. It's very strange. Anyhow, so back to where we were. And also I did catch quite a bit of Andrew's presentation as well. So I think it really sets the position of where the Online Safety Act sort of fits. And now what we can do is sort of broaden it out a bit more and think about how this concept of risk assessments can apply more broadly as we think about ethics and safeguarding in other projects too. So a little bit of background on me. I will whiz through my background, a bit of background on me is you may know of Limina from when we would tour various parts of the UK initially with our virtual reality theatre. We were very much known for taking immersive media, so VR, AR, to much broader audiences than sort of were initially experiencing it. So it would be often kind of creative and artistic content. Before that, I produced two of the BBC's first public-facing VR experiences. That was sort of where I really got this sort of bug for wanting to get VR and AR out there. And reaching that audience base. But we also got to see, through meeting so many audience members, their anxieties, their hopes, their fears, dreams around this new medium, and around emerging technology generally as well, especially when it's used in a kind of creative capacity. So we did quite a bit as well as the VR exhibition of sort of consulting, and we would share as much as possible what we learned through research projects. So these are some of our clients that we work with, and actually now, as of sort of 2020, we're now fully in consultancy and research mode at Limina. We weren't able to do our events anymore, so we work with wonderful partners, and now that's what we really focus on. So you'll see here some examples of partners that have commissioned reports or specific research projects from us that have been published, including NSPCC. And yeah, if you want to check out some of our work, these are two really quite, I guess, positive reports that we released around how proactively you can create different types of content, what really works with different audiences and inspiration for that content, and also how to widen appeal for virtual reality specifically with in the context of events and physical spaces. So these are really show off where the medium immersive technology can go. And I think you can apply quite a lot of this, especially our Beyond the Early Adopter report for Nesta's Policy and Evidence Centre. You can apply this thinking, I think, to a lot of forms of emerging technology and creative spaces. But then also we've looked at the dark side and how the harms can be mitigated against, specifically for immersive technologies. So this is really where that combination of seeing the potential, but also the potential harms as well, has really been helpful for us as a research organisation. So I would recommend, if you're interested specifically in VR, then check out these reports, one for IET, one I mentioned earlier that Rich and his team commissioned from the NSPCC, specifically looking at harms to children, and is quite relevant as well to the Online Safety Act. But yeah, what I want to sort of highlight is start off with just highlighting is the power of emerging technologies. And you're probably thinking, why have I got this slide up of poor old Aunt Marge going up like a balloon in the Harry Potter film, the first film, when he's learning how to use his powers responsibly. And at this stage, at this really early stage, he hasn't learned how to use his powers responsibly. So he's got this magic, technology being like magic, you see as a sort of theme here. He's got this magic capability. It's like, I guess it's like we've got these magic capabilities, but as a society, do we know how to use them yet? I often come back to this quote, the third law of technology from Arthur C. Clarke, that any sufficiently advanced technology is indistinguishable from magic. So we have to learn how to use this magic responsibly. But the great thing is that in the UK, we are really, as I mentioned earlier, the cultural sector is very good at caring about ethics, about diversity, about safeguarding, and specifically in physical spaces, I think we've got real sort of excellence. So we come at it from a good position, from a kind of, I think internationally people often look at Britain for that. So we're in a good position really to be thinking this way. And cue the Online Safety Act, we're really well, I think, well positioned. So digital projects from the arts, when they apply to the Online Safety Act, they're in scope, in a good place to be understanding those risk assessments, and to be embracing this regulation even. And when they're out of scope as well, then we can start thinking about this more broadly, and think about the sort of principles. So what I'm going to do is take us through some the concept, which you're all very familiar of already, of risk assessments, but we're going to apply it in a different way. So key to the Online Safety Act is this duty of risk assessments, and I'm going to tell you some cautionary tales where things have gone, technologies within sort of culture, but also beyond as well, outside of the cultural sector, where technologies have been launched, they've had loads of potential, but there have been issues that have caused sometimes quite significant harm. And these are issues that could actually probably have been mitigated against beforehand. So I'm going to tell you some cautionary tales. But what I'd like you to do is, if you have pen, paper, or your notes app, jot down the risks that become real when I'm talking about these real harms. Jot down what these risks are, the likelihood that would have happened, and then the mitigation that could have been put in place to stop that harm occurring. Or even just think about what was the likelihood of this happening? Was this actually quite a freak incident, or is this actually something that they really should have, like it was without a doubt going to happen? And then what could have been put in place to reduce the severity? So let's start with cast your mind back to 2014. Does anybody remember this term, glass holes? This was when Google launched their Google Glass product. And Google Glass, as you may remember, really early augmented reality product that overlaid things onto like objects and text onto the top of the world you're in, but it also could record video, and it could take audio too. So and it had a sort of voice recognition way of controlling it, as well as tapping on the side. This launched in 2014. to lots of, sort of acclaim in the tech circles, and fancy parties that they were. I remember going to a sort of a launch party in London for it. The problem was, though, is that when it actually, quite quickly, they wanted it to go more mainstream. And so they were really pushing out, which, you know, it's a good thing to go mainstream. But what hadn't happened is the sort of the consideration of the ongoing recording, and how the ongoing recording, and this little red light as well that tells people around that you're doing that, how that would really be quite disconcerting for other people around the user of the Google Glass, creating this term glass holes, becoming quite commonly used, and experiences where even leading to people being assaulted in the street, sometimes in instances of people in bars being refused entry. Here's some examples. Woman claimed she was attacked for wearing Google Glass at a bar, a journalist who was assaulted on the street for wearing Google Glass. So there was a backlash. So I just imagine that you're in, say, cast your mind back to 2014, say you teamed up with Google Glass team for a sort of in-person site-specific theatre experience, maybe heritage tour. What, if you want to think about from a sort of arts and culture context, what kind of mitigations, thinking back to our risk assessments, might you have put in place for, if you could imagine that you could have envisaged that this could have happened? So there's an example of, you know, the harm actually to the end user, which also, and then a broader societal concern as well about privacy in public space. So that's the thing to think, I guess, just to start off, just to get you thinking. I will now take you to the next cautionary tale. This is in 2017, so a few years afterwards, and this is Shia LaBeouf's He Will Not Divide Us. I don't know if you've heard of this live stream arts project that Shia LaBeouf launched after Trump got in. He wanted to make a statement. Clearly, he will not divide us. So he set up a live stream camera outside the Museum of the Moving Image in New York. And he set this camera up, and people were invited to come up and chant and show protest slogans, placards, to put up that messages of resistance and not being divided. It's the idea of it really was, it was actually about bringing people together. But what happened was people and the people who took part, the participants, quite a few of them were targeted by online Trump supporting individuals, could say trolls, who would follow them around the internet, subsequently found out their identities, doxed them, trolled them, lots of online abuse, which included sort of racial harassment and hatred. It became very serious, even involving real life assaults. So there's another example of it. It actually came to fact in Liverpool as well, and in a different iteration, but still there were issues, and it became sort of unfeasible. So yeah, how could this risk have been mitigated? And I'll give you one other cautionary tale, which is the Best Buy pink eye issue. So this was again in 2017, and this is thinking about virtual reality and a more of a health and safety form of safeguarding, but also I think it does speak to, of course, ethics more generally, which is where Best Buy ended up having to withdraw their Oculus, which is now the Meta VR headset device. They had to withdraw the demo VR headsets, and the reason, a rumor had it, why, was because of a conjunctivitis outbreak, which they call pink eye in the States. There was also cases of these conjunctivitis outbreaks in tech conferences as well at the time. And really is the case that I did a bit more research into this, like, is it just rumor, is this, and look, there was a study I found that showed about how VR headsets really do harbour germs. There was a study, from University of Mississippi that found all sorts of germs just on a lab-based VR headset, involving people getting food poisoning, MRSA germs, even some quite severe potentially, especially for someone with who was immunocompromised, some quite severe ramifications. And that was just a general university computer lab in Mississippi. So the result is that people, can have quite serious health consequences. So how can this risk be mitigated? I know certainly at Limina how we mitigate these risks and how obsessed we are about VR headset cleaning. There's another area, another one to ponder on, to think about. And now I want to give a more positive, this is sort of starting to wrap up, a more positive tale, which something went really, really right. And this, actually, I don't have, the slides have changed in all my internet commotion, so I'll just tell you about it. So this is to sort of leave you on a much more positive note. Back in 2016, you may know of the VR documentary that I produced at the BBC called Easter Rising, Voice of a Rebel. And this is a VR experience that you get to live through the memories of a rebel in Easter Rising of 1916. We released it for to mark the centenary 100 years later in 2016. And you're really seeing his experiences doing something that nowadays would probably be described as treason, terrorism. It was treason at the time, but terrorism now. We were aware it was, I guess, editorially and from an editorial policy perspective, a hot potato. And there's things that really could, real risks, that could have happened. So, for instance, we were worried that Easter Rising, Voice of Rebel as a VR experience could have actually been used as propaganda for violent modern day groups. Obviously tensions in Northern Ireland, it's not finished, it's not done. And there's a risk of appearing to sort of claim truth, causing online arguments, potential bias for BBC. So we had these potential issues, but because we mapped this out, I worked with the editorial policy team, who are absolutely brilliant at the BBC. We worked out ways of mitigating. We realized actually the best way to do it is through creativity and through bringing in theatre practitioners. So we use, for instance, Brechtian techniques to mitigate risk of sort of romanticizing the character. We also really actually rejected the idea of an empathy machine, which was very trendy at the time for VR, and decided, no, that would glamorize this. So yeah, bringing in creativity to address these risks. So these risk assessments, they don't have to be, let's go back, they don't have to be something that feels like a sort of an admin task. Actually, you can have really creative responses to them. So I just leave on this point really, which is that mitigating the risks of emerging technologies in your projects actually allows us all to seize the opportunities, because there's so much opportunity that can be brought. It gives you a foundation of safety then for all sorts of creative opportunity and wonderful experiences for audiences. And I think we maybe have some time for Q&A from me, but we might have to, Linda.
yeah, I think we've got 5 minutes, because it's, so I feel like because we've done things two ways around, it'd be really a good moment to sort of pull it together. So sort of thinking about, thank you very much for all of that. Any more questions for Catherine? Pop them into the chat now. But I think there's a couple of things really, which is sort of, so what you're saying is risk assessment is key to all of this. Have you got any kind of top tips for people thinking about risk assessment in terms of online safety and ethical risks for audiences? What would your sort of top thinking be?
Start really early on, when you first have the idea of what you want to do. Embrace then thinking, okay, let's map out. There's a term you may have heard of called consequence scanning. Let's scan through the consequences. I believe it's .everyone who they sort of pioneered it and have an open source toolkit that you can download. I think starting off where you look at the consequences, even of that early gem of an idea, and enjoy that process while it's hypothetical as well. That it can make, I know it sounds an odd one, but it can actually make this brainstorming fun. The earlier it is, then the less it's not contentious. So think about this really, really early on. Think about ethical risk. Get clued up with the Online Safety Act, of course, but then you can use those principles from the Online Safety Act of a risk assessment to other things as well.
Okay, right. So really sort of back to key principles, think about what you're doing.
And really, as soon as you have an idea for something, like super early on, so that you can actually enjoy the process and it doesn't feel scary and something that, you potentially isn't a pleasant task to do that risk assessment.
Okay. And as Andrew was talking and when you were talking, we've had a few different questions in the chat, which are really about people saying, well, it's to do with who would be responsible. So we've got somebody who's in a charity, somebody who's in somebody in a local authority situation. But so I suppose the bigger question is, and Andrew's come back in again, what should arts and cultural organisations be thinking about? What do they need to be checking here? And if and who does somebody within their organisation need to take responsibility? Does one of you want to take that first?
I think that might be more for Andrew to start.
Yeah.
Okay, you kick off. Just a bit of clarity for
yeah, I mean, so in the draft, some of the draft guidance, one of the things it says everyone who is within scope will have to do is have a named person that's accountable to the most senior governance board. So, someone in the query had a question about charities. It doesn't say that it has to be signed off by the board. It just says that they have to be accountable to the most senior person in the board. So that's all it says really. For now, there aren't any sort of real specific requirements other than that. And to the local government question, about the question there, for those who haven't read it, is, so if we're a local authority library service, we're exempt, which sounds right, but we commission an artist to deliver a project, an arts project, and then they share that via their own website. Where would the responsibility for compliance lie? Well, it would be with the artists, because it's their service that users would be accessing. But that then comes to my point, one of the points I made at the end, which was, it may be prudent to if you're contracting with them, to say, we need to know that your platform, your user service complies with the Online Safety Act, like you would with data protection. I mean, it's a bit more stringent on data protection, because you do actually obviously have to have contractual terms between the parties if you're sharing processing data. But I think a similar approach should be a prudent one for those who are commissioning third parties.
Thank you very much. Catherine, have you got anything to add to that? Just thinking about maybe smaller arts organisations, or people think, oh, would we have to worry about this?
Yeah, I guess it's also to sort of broaden out from, if we're looking at risk which is not within scope of the Online Safety Act, I think it's always good to have a champion of this particular area. However, it shouldn't feel like a nag, I guess. And so keeping an eye on if you've got a special area that you've had some grant funding to create a sort of user-generated content platform for something artistic and creative, you should have somebody whose job it is to be on top of the potential harms and the emerging harms in this field, in this space. But it's sharing that in a way with the team constantly, where everybody's aware and wants to champion it also, I think is helpful. Otherwise you can have situations I've seen in sort of VR projects where somebody is sort of the one who's saying, oh no, sorry guys, can't do that. That's not what we want. I think seeing how the BBC did this, working with me as a producer, I actually really enjoyed my editorial policy meetings, where often they would say, oh, we don't know if that's, should you consider that? Or we don't know about the implications of this. They were really interesting, fruitful conversations, again, because they happened early on.
Yeah. And so it's just think about things creatively and early enough on to sort of resolve the issues. And
think of a champion even within a small organisation of this area, yeah.
Okay, so we're going to wrap up and have a little break, but just before we do, is there anything else that either of you wants to say that's really, rather than we'll get into the specifics later, because we're also going to hear from Rich, and he's talking about some of the kind of myths of this, so we'll have a bit more sort of material to work with. But is there anything else that you'd want to say to arts organisations and cultural organisations at the moment on a sort of general level about thinking about ethical risk? Or have we covered what you wanted to say?
I'd say something that might be helpful is if you're, say, doing a grant application for a certain emerging technology, for instance, just spend some time getting across what the existing cautionary tales are of that existing technology, what's happened in the past. You can look sort of last 5-10 years for something like augmented reality or even AI to see where, the learn from others' mistakes, I guess. So spend some time doing that. As somebody who's sort of been in judging panels, etc. Sometimes it feels like someone's not done that. So I would say, yeah, get across the cautionary tales in that subsector.
Smashing.
Yeah.
Thank you very much.
On a similar note, yeah, I think education within organisations is always a good idea. You know, there's lots of developments in this space, so you know, understanding at a minimum what's in scope, what isn't in scope, just in case you are doing projects that are in scope, you might need to take some steps. Similar with AI, you know, I think that's something that everyone's having to grapple with, and it's sensible to have a bit of education within the team. You know, what is AI? What are the risks? What's our policy on using it? How should people use it? What can and can't we put into AI tools? So it's just kind of stressing, yeah, I think education is always a good step to take within organisations.
Smashing. Thank you very much. So we're going to take a 5-minute screen break now. So thank you for your contribution, and you'll come back after the break. And to everybody else, if you've got any questions now, might be a good time to pop them in or to have a bit of a think about what we've heard. And after the break, which is just 5 minutes, so 12:08, I'll come back on and I'll invite Rich to join me, and he's going to talk about the NSPCC perspective and some of the myths around the Act and his involvement in developing it. And then we'll have Q&A at the end with everybody. Okay, thank you very much, and see you after the break. That was a very speedy 5 minutes, and I'm going to invite Rich Collard to join us now. Catherine introduced Rich at the beginning, and we talked a little bit about his work as a policy advisor with NSPCC. So, Rich, over to you. I think we've got about 15 minutes for this section, and then we'll have a little time for questions at the end. Thank you.
Amazing. I'm just going to try and share my screen now. Can you just let me know if you can see some slides?
We can. That's it. Perfect. Perfect.
Excellent.
Great.
Thanks a lot for having me, everyone. I'm Rich. I head up the Child Safety Online Policy team at the NSPCC. I've been with the NSPCC for about 2 years now, and most of that time has been focused on pushing the Online Safety Act, was once a bill, through Parliament, defending it against a lot of attacks and trying to strengthen it wherever possible. In terms of what I'm going to cover today, I'm going to talk a bit about the origins of the bill, some of the work that we've done at the NSPCC. I'll cover a little bit of what I see as in scope and out of scope, including some of the myths that I think sort of surround the bill, and try and tie that into what that might mean for some people in the creative industry. I'll caveat it first and say, until Catherine approached me about this opportunity, I hadn't really thought of it through the lens of your sector before. So yeah, happy to hear, challenge, and yeah, I think this should be a good conversation. The other thing that I will say, just as part of the why, the sort of online risks to children, I will mention things around child sexual abuse and harmful content to children that obviously some people might find distressing. So I'll probably only spend a couple of minutes on those slides, just talking through some of the risks that we saw. So if you do want to jump off and join again in a few minutes, hopefully you would have covered that by then. Just kicking off, this slide here shows a bit of the backdrop of harms that children were and still are receiving online. I think the sort of top left is the clear one, which is why the NSPCC, a child abuse charity, got involved with looking at pushing new online legislation. And this is just the vast increasing numbers of children being groomed online. I think over the last 6 years, it's up about 80%. And there are a range of other harms that we've seen, whether it's inappropriate content being amplified to children. Only, let's say last year, 2 years ago now, a coroner concluded that 2 technology companies, Pinterest and Instagram, were directly contributed to the death of a 14-year-old child called Molly Russell, which was quite a big news story at the time. But for us at the NSPCC, we were seeing a range of calls come into Childline. We were hearing directly from practitioners, and we thought we need to do something about this. And we were considering at the moment, there's a vast array of safeguarding architecture that exists for children. You have schools that play a role, you have parents, you have children playing a role themselves, but actually technology companies where this harm often takes place can play a direct role in either reducing harm to children or amplifying harm to children. So I'll give you a quick example of that, but you can think things like friend recommender algorithms, while very innocent to me and you, but in the hands of a child abuser, can quickly recommend more and more children for them to quickly add and potentially groom. And if you think things like recommender algorithms or moderation technology, that can be used in one way or another to amplify certain types of content. And some of that content is often age inappropriate and can keep sort of children stuck in a cycle of viewing harmful content that can lead to some pretty gruesome outcomes. I think it's probably just worth saying as well that what we did take the view as the organisation was actually the solution is not to keep children from being online. There are multiple reasons that people, that there are lots of benefits that children receive from being online, whether it's to learn, to play, to communicate, and they shouldn't be blocked out of that. So actually saying, the internet should be for over whatever age or focus on screen time wasn't the answer for us. It was actually, how do you make sure the platforms where this harm's taking place are fundamentally safe by design, and you build that in at the outset. And that's what we took the approach of pushing for a sort of duty of care model. I'm going to jump over to the next slide. So this is where I'll definitely disagree with Andrew and say actually online safety bill origins were way before the white paper. And we've been, as the NSPCC, one of the first organisations to start calling for social media laws. And it was about 2018 that we had, I think it was Matt Hancock at the time, commit to introducing a online safety act. And obviously it's but sort of do agree with Andrew that there's been lots of alterations to the bill over time, and we've seen it be strengthened, be weakened. I think since I've been working on the bill, we've had 3 prime ministers, but also probably worth saying that we've had about 5 secretaries of state working on it, and it's definitely ebbed and flowed, and there have been some that wanted to deliver it, some that haven't, some that wanted to completely destroy it. And what we've ended up with is a bill that I think does a really good job of protecting children, and that was obviously passed earlier last year, essentially, and is in the implementation stage at the moment. But I know Andrew flashed up the roadmap. The roadmap's quite a long process until everything has been implemented. We're looking at about 2025. I won't go over this slide in too much detail because I know this is something that's already been covered, but I think it just goes to the point that what is in scope is the regulated service providers, it isn't individuals. And I think that's the really important point to take away from this. And really the focus is on, I suppose, 3 things, although I'm probably oversimplifying this. One is to remove illegal activity or content. So from the NSPCC's perspective, this is to make sure that grooming doesn't happen online, that people aren't trading child sexual abuse images online, but there are other illegal harms that are also tackled through this. Things like intimate image abuse, so sharing another person's, unconsensually sharing another person's nude, for instance, is banned from this. Protecting children from harmful or inappropriate content, I spoke a bit about this, but what we mostly mean is things like content that glorifies suicide or self-harm. And then there are also some powers in it the bill sort of forces tech companies to empower adults to choose what content they may or may not want to see on their platforms. I thought this slide is quite helpful for just really getting to grips of like, what do we mean by who's in scope and who's out of scope. So firstly, I mean, it's that point I've made again, it's the online service companies, it's not individuals that will be held responsible. And when we talk about online service companies, we talk about user-to-user services. So that's your social media platforms, your Facebooks, your Instagrams, your messaging sites like WhatsApp, and search organizations. And I suppose it kind of does creep out. So you have things like online games, if there's a user-to-user function. So for instance, if I'm playing something just online on, I don't know, if I'm playing Call of Duty or whatever else, where I'm sort of can have conversations with people, that would be considered in scope. I think things that are outside of scope of this are things like marketplaces, gambling websites that have their own legislation. The sort of next row, I think, is quite important to draw out, is that what Ofcom is regulating is it's regulating platforms for their systems and processes. So what it's going to look at is say, do you have the right systems in place? Are you using the right age assurance technology to know the age of your users? It won't be looking at individual pieces of content. Obviously, if there's issues with thousands and thousands of pieces of content of the same type, or something that's amplified massively by a platform, that might be considered problematic, but only if they look at it from a systems point of view. So what were the systems that allowed that piece of content to be amplified to such a large audience? So that's how they'll start to look at things. So they won't be taking individual pieces of content and saying, Facebook, you have one problematic image on there, now you're sort of in breach of the regulations. And I suppose the other thing, I mean, I've sort of touched on it before, but really it's about platforms being required to remove illegal content and harmful content. But what there are in place in the bill is protections for things like journalistic content, democratic content. There are specific rules that mean platforms have to still protect freedom of speech. So there's a real balancing act that the platforms are going to have to play. This slide here just tries to dispel a few of the rumours that I guess flow around when people talk about the online safety bill, that it's a divisive bill, that it's controversial, that it's a sort of threat to either privacy or freedom of speech. So I'll just touch on each at a time. So the first one is that it's divisive or controversial. I think that's an overstatement. The online safety bill had actually support of both of the main political parties, and actually the conversation was very much around strengthening the bill rather than whether it was appropriate or not. And again, the bill had support of both the House of Parliament or the House of Commons and the House of Lords. So I think that's a myth that I dispel. The next, on the right, this is from the Open Rights Group, and they have been sort of pushing the argument that this is a bill that's designed to essentially become a monitoring state in some sort of 1984 realm. And I think essentially this comes down to the idea that whether or not we should try and remove child sexual abuse images from the internet. And at the moment, there are well-known techniques that have been used for quite a few years. I'm talking about 20 years now, rolled out by most of the large platforms that essentially determine whether an image uploaded is of child sexual abuse, and if so, remove it and report it to the authorities. Essentially, there is a bit of a push to try to claim that by doing this removes all our privacy, which I would definitely disagree with, but that's one of the arguments that have been put forward by some of the rights groups. And the last tweet there that I have on the screen is a tweet that someone actually sent to me after I put out a tweet celebrating the passing of the bill. And they said, "Tyrants have destroyed free speech in the UK." And again, this goes back to a point that actually this bill is about stopping children from seeing age inappropriate content. And if that's what destroying free speech looks like, I've sort of put my hands up there. I don't really know how to respond to some of these sort of attacks on the bill. But ultimately, my point here is that I don't think it's a diversive or controversial bill at all. It's a sensible bill trying to force large technology companies that can play a role in stopping harm from playing a role and not just sitting back and saying, this is all up to the people on the platform. So this last slide here, this is where I tried to think, okay, what would it mean for someone working in the creative sector? And I suppose the first point here is, if you're designing a user-to-user space, that needs to be safe by design. And when I say user-to-user space, I mean something that online two people can communicate or multiple people can communicate. So that could be a forum, that could be creating the next social media app, that could be creating an immersive world in the metaverse or a game that people play on. And that really needs to be safe by design. And I'd say if you're in that category, then it's definitely worth probably looking through the online safety bill, because there's a lot of Ofcom are going to be really, what's the word, proportionate. And depending on how large you are as a platform, depending on the level of risk, you have more things that you do have to do or don't have to do. So I'd say it's worth looking at that. I'd say if you're just a content creator, as opposed to someone who's hosting the content on a sort of user platform, actually, I don't think too much changes for you, because firstly, you'd need to, what the bill does do is make sure the platforms are removing content which is illegal or not within their terms of service. So illegal content, we went through already. I assume you guys won't be creating that. So that, I think that doesn't really apply to you. Within the terms of service of the platform, one of the things that the bill does do is make sure that these online service providers are enforcing their terms of service. So if they say, if Instagram says we do not allow pictures of topless women, then that's what will be enforced, and platforms will be expected to keep to that. And there will obviously be complaints procedures in place. If a platform does allow that, then fine, that's absolutely okay. But it's just making sure that what is in their terms of service is actually enforced. And then the last thing that I thought would impact, if you are creating content and wanting that content to be viewed, there are protections in place to make sure that children are not seeing age inappropriate content. So that could dictate how many views you get. And again, there are tools to empower adults to have greater control over what they do and don't see and what they engage with, so could impact views. But ultimately, this goes back to the point that I have, that this is really about the technology companies themselves, and Ofcom will be a proportionate regulator. Their focus is on the larger tech companies at the moment, or the companies that have the biggest risk to firstly children, but then sort of wider harms. So my takeaway from this was, I think that most of you will not have your sort of businesses or your art ultimately too affected by the passing of the bill. But that, I think, is the end of my presentation. And that's a someone else's name because I stole their slides to do this.
Well, thank you for stealing the slides, because they're really excellent and clear, and that was super, super helpful. That was great. Thank you, Richard. And the question, and do you think the person who wrote the slides will be okay with us sharing them to the wider?
Yeah, I mean, the vast majority of it was mine. I just used their template, so I'll correct that at the end.
Smashing. Thank you very much. So we've just got sort of 5 minutes for final question. And I suppose I want to ask the audience, because I think the biggest question that keeps coming back is, are people asking specifically, is something particular in scope? So perhaps my question to the audience would be, is it clear to you, the audience, what is and isn't in scope? Are you going away from this more sure that what will or won't affect you? So we can just see in chat what the answer to that question is, because I think that's what I want to, that's the sort of key thing that we want from today, isn't it? People having an understanding. Okay. Yeah. Okay. All right. Is there anything else? Yes, because it would seem that, you know, if somebody's doing an audio drama that you download on a headset and walk around, that's not in scope in any way at all. Yeah, you can see people are saying yes. So it seems like we've got the key message across. All right. So apart from that, I'm going to check with the audience. Do you have any other questions for our panel. We've really only got 3 or 4 minutes left, so let's just check and see if there's any other question from the audience, or anything that Andrew, Catherine, or Rich you'd like to say in response to what's above. Okay, or what's happened before. Anybody want to make any last comments? Okay. Oh yeah, so somebody's asking, this is quite a good thing. So there's 2 things. Rich, there's a question to you that you might want to answer in the chat, but it was to do with the NSPCC approach, and I don't think it's necessarily to do with digital, but it's a wider question. So it's the question is back up here at 12:15. There's a question that you might want to respond to. And Catherine, if we find ourselves on a project needing further advice, where would we go?
Well, looking at Ofcom, so if it is in scope for the Online Safety Act, then Ofcom have got really, really detailed guidance already, still in draft form, but that will be updated. So you can keep an eye on what Ofcom are up to. If you're talking about advice more generally, about so considering ethical risk and doing risk assessment, etc. I think having peer-to-peer support would be a good, like you could, for instance, like establish a group in your of organisations in the area, meet regularly, because as I mentioned earlier, the cultural sector has so much within already. It's just applying thinking differently. So doing that together could really help. Also, I'm more than happy for you to, get in touch. I'm about to go on maternity leave, but up until the end of January, if you've got any little questions that come out of this, do feel free to drop me a note. You can get my email address from the Space team, or post sort of June onwards and get in touch.
Okay. And before I think we are going to run over by a few minutes, because I want to give everybody a chance to have a sort of final question. But what we do at this point is we have an evaluation survey, which is essential to all our webinars, because obviously it helps us to understand what we're doing well, what's working, what more you would want. So we're going to give a minute just to put the link to the evaluation survey into the chat. So you've got a chance to fill that in. It really is, I think it's about 5 questions, which will give the speakers a chance to just collect their thoughts and think about, is there anything else that they would want to add in? And while you're looking at the evaluation survey, I'll just be reminding them of some of the questions that came up, if that's all right.
Well, I'm happy to answer Carol's question.
Oh yeah, you if you do that, and then we've got the evaluation survey, so we're asking people to look at that. So Rich, go ahead and answer Carol.
Cool. I think I agree with you that intersectionality does really affect children, and it can exacerbate particular harms. For instance, if we know that LGBTQ+ children are more likely to be affected by abuse, and I think ultimately this is something that we are cognizant of as intersectionality as a whole. And what we would say is that platforms, when they are considering the harms to children, need to be thinking about things through these lenses as well, because ultimately some solutions might benefit certain groups and others might need a sort of tailored approaches. But yeah, we're cognizant of those risks, and I think the only reason it wasn't included in the slides is because I had sort of 15 minutes to present quite a big topic.
Thank you very much.
There's a question that somebody's asked that I thought was quite important one, which is, what's the sanctions if it's not adhered to? And I thought maybe that's one for Andrew.
Yeah, so it's fines up to 18 million or 10% of turnover, and they're criminal sanctions senior managers. Also talks about blocking orders against services that don't comply, but obviously that's at the very extreme end of the scale, and I think ultimately that's for the much bigger organizations. But those are the sanctions.
I think I'm sort of reflecting back on when we set this up in the first place, and Catherine's point very early on that perhaps this is our opportunity to start thinking, the fact that the bill has now become an act is a point to think about. Question, are we doing everything that we can to mitigate ethical risk and look after safeguarding users? And that feels like the key point, really. Any anything else that anybody would want to add? I think we've answered all the questions so far. Does anybody have anything else they'd like to?
I guess I think the final thought, obviously, just scaring everyone with those remedies that Ofcom can use. You know, I think the whole ethos is proportionality as well. So, you know, it's not something you need to panic about. That doesn't mean ignore it, but similar to data protection, certainly when we saw GDPR come in, there was a mass panic and people went completely crazy over it, and it was sometimes unnecessary to do so. So I think the message is, again, do the risk assessment, learn as much as you can, and put in place the steps that are proportional to your business. Really, you know, common sense stuff.
Thank you. Does that feel like a very good place to end? The final bit of advice. Okay. Well, thank you very much, everybody. Thank you to all our contributors. Thank you to the audience for your questions and so on. And if you can fill in the evaluation, if you haven't done it already, that would be brilliant. And just to say, our next webinar will be on the 27th of February. We haven't launched the details yet, but we're really looking about sustainability and environmental practices in production, and the questions of how digital comes up there and how it can be useful. So I hope to see some of you there. Thank you very much, and enjoy the rest of your day.
Thanks all.
Yes.